The Committee on Appropriations is called to order with Secretary Pickle.
Representative Chavez.
Here.
Representative Espinosa.
Here.
Representative Fernandez.
Here.
Representative Fillmore.
Here.
Representative Freeze.
Here.
Representative Kern.
Here.
Representative Roberts.
Here.
Representative Thomas.
Here.
Representative Udall.
Here.
Vice Chairman Kavanaugh.
Here.
Chairwoman Cobb.
Here. Okay, so members, this is our last agenda today. Yeah, I know you're all sad. But this one is probably the most difficult one because we've had a lot of strike everythings. We've had amendments placed. This is one of those that is, it's the last, as you said, Mr. Kavanaugh, the last helicopter out of Saigon. So we are going to have some difficult issues coming before us today, as you saw on your agenda. The order that we're going to go in is, I'm going to try to do 1101 first. And then we are going to do 1225 second. Then we are doing 1097 third. Then the fourth will be the, which is this, fourth will be the, it'll be 1424, and then fifth will be 1001. Now with 1101, we did a strike everything amendment. We do have some concerns with the strike everything amendment. I do personally, and it's in my name. So I am going to have this for discussion only today, and we're not going to move the bill. So would staff do the strike everything amendment? Thank you.
Madam Chair, members, I'm Josh Spears. I'm the research staff attorney and Judiciary Committee analyst. Right now there's a 2-year statute of limitations for most personal injury lawsuits. That's told if the plaintiff is under the age of 18, meaning a minor who's injured will generally be able to sue until the age of 20. The Strike Everything Amendment to SB 1101 creates a 12-year statute of limitations for personal injury lawsuits brought by a victim of childhood sexual assault or by a child against someone who failed to report child abuse or childhood sexual assault. The Strike Everything to SB 1101 also revives time-barred claims based on this conduct. SB 1101 would allow any victim under the age of 31 to bring a lawsuit based on childhood sexual assault until the person is 31. SB 1101 would also allow any victim over the age of 30 who has a time-barred claim to bring a lawsuit for up to 1 year after the effective date of the new statute of limitations. And I'm available for questions.
Any questions for staff? Thank you. We have the sponsor here, Senator Boyer.
Thank you, Madam Chair. For the record, State Senator Paula Boyer, District 20. Thank you for at least giving us a hearing. Up until now, we've been silenced. Nobody has given us a hearing. This is the most important bill you will have before you all year, all term. The protection of Arizona children. The one thing we know about perpetrators, those who sexually abuse children, is we know that they don't stop until they're caught or they no longer have access to children. The reason why we're running this bill today, why I'm running this bill, and why I have so much support from members, apparently not from those in control, but the reason why I'm running this bill today is Arizona's the worst in the country regarding our statute of limitations for children who have been sexually assaulted. In fact, we don't even have a separate statute for children who have been sexually assaulted. It falls under the personal injury statute. So that means the same guy that slips on a banana peel at the restaurant, that's the same statute that children who have been sexually assaulted falls under. Just to give you some context, in Arizona, any contract, you have 6 years. If you have any dispute, you have 6 years for a contract dispute in the state of Arizona because of the statute of limitations for contracts. But yet we give children 2 years. Perpetrators who know the law, victims don't know the law, but the perpetrators who know the law know that all they need to do is move to Arizona because all they need to do is wait out the victim for 2 years. That's it. And if the victim comes forward after they've been time barred, after those 2 years, at the age of 21, they could have all the evidence, corroborating evidence, other eyewitnesses, other victims who have been assaulted. They could have all the evidence in the world, and they could be sued by the perpetrator for libel in Arizona. Imagine that. And doubly victimized again. There's reasons why victims don't come forward right away. The emotional, the psychological trauma of being sexually assaulted, probably by someone they knew. This isn't happening for the most part by the guy offering kids candy at the park. This is either in institutions, family members, friends who know these children, who groom them, who tell them, oh, you wanted it. It was well, you were interested in it. They have 2 years from their 18th birthday to file a claim. Let me give you just one story, an email that I received. And I'm not going to share her name because she didn't give me permission, but I'm going to share her story today. I want to write to you about a very personal issue. You recently brought forth statute of limitations to the Arizona Senate, and it didn't get heard by the floor. I want to let you know that I myself was raped, and immediately after it happened was picked up by the Phoenix Police Department. It took almost 2 years to complete the investigation and to pass on my case to the district attorney's office. I only just today managed to get the police report, and am totally crushed to learn that I have too little time left even to attempt to file a civil lawsuit against my rapist or the cab company he worked for. The statute of limitations for such a lawsuit is only 2 years from the incident. I reported the incident immediately after it happened, and the 2-year statute of limitations for civil lawsuits in the case of sexual assaults means that I cannot even attempt to hold the cab company or the rapist himself liable for any personal damages I experienced from the incident. There is nothing I could have possibly done to make my case investigation be completed in a more timely manner. The police department doesn't even have the proper resources they need to process these types of cases in a timely manner. I'd like to ask that you please push for this bill to again be heard by the Senate so that I can have the opportunity for justice to be carried out by the trauma that I experienced. Members, just to let you know, Arizona is an outlier. Just the surrounding states. I just pulled the surrounding states. New Mexico, 3 years. They have a 3-year, essentially a time frame from which the victim should have known or reasonably known that they were sexually assaulted. So that New Mexico has 3 years. Colorado has 6. Utah has 4 years. California has 3 years. Nevada has 10. We're asking for 1. I've done a lot of work with the Internet Crimes Against Children unit, and what some of the investigators have told me during their investigations, when they investigate an alleged individual who is sexually assaulting, taking videos, pictures of children that they have sexually abused in the worst possible manner, they have told the investigators, you have to lock me up. I cannot stop. The one thing we know about perpetrators is they don't stop until they're caught or they no longer have access to children. The reason why the window is so critical, and this is just a fundamental disagreement with the opposition, is that's the only way to stop current perpetrators from harming children today and also to prevent future harm. By not moving on this bill is a public harm not just to the children that are being sexually abused, but also their future. Their future is in our hands. And so, Madam Chair, I'll stop talking at this point because there are a few folks that's more important to hear from than myself. before we hear from survivors, if with your permission, I'd like to call up Senator Contreras, if that's okay.
Do that.
Oh, and I should mention, the members, you received an email, I believe yesterday, from insurance saying that the bill before you is unconstitutional. I have case law that says otherwise, and so with your permission, I'd
You
like
may.
to distribute that to the
You may.
committee.
Madam Chair, I have a question.
You may.
Are you distributing, while you're distributing, how many cases are you distributing?
We have Arizona case law, and then we also have 4 other cases dealing specifically with sexual assault, saying that indeed what we're doing is constitutional, as you'll see from the 2-pager.
Thank you, Madam Chair.
Mr. Toma.
Madam Chair, Senator Boyer, what is the definition of sexual assault?
Madam Chair, Representative Toma, Arizona is very specific in statutes. 13-1406. Subsection A, a person commits sexual assault by intentionally or knowingly engaging in sexual intercourse or sexual contact with any person without consent of such person.
Any other questions of the sponsor? Mr. Boyer, I just want to say thank you so much for bringing this to light. I know that we just worked in the last day trying to get the Strike Everything Amendment,
you.
and we have some problems with in the 1-year window, and I think we could tighten that up. And I'm giving you my word. I will work with you on this.
Thank you, Madam Chair. Madam Chair, members, this is so important to me that I was considering stepping down after this term. But if I don't get this through this year or next year, I'm running until I get this passed, because this is that important for victims.
Thank you.
Thank you.
Thank you. Senator,
Good morning.
good morning. How are you?
Good morning. For the record, Lupe Contreras, Senator District 19, Madam Chair, members of the committee. This is not an easy subject to speak about, and it's something that I want to thank Senator Boyer for allowing me to be, in a bipartisan fashion, side by side on this, and we've been working on this for a couple of years, and he's had a lot more legwork than I've had on it. But whenever something's come up, he calls me and we get things done, and we try to, well, or at least we try to get something done. It's short of breathtaking to hear the testimonies that we've heard and the people that we've spoken to and the people that have spoken to us in regards to this issue, and why it's taken so long. And when we talk about these people coming up to us, it brings up a lot of old memories. Myself and Representative Espinoza, our families go back 4 generations in the same town. And in our parish, this issue happened. We're not here, and I by no means got behind this issue to attack any organization, but I stand proudly as a Catholic, and I say that with loud words. I am a proud Catholic, but I am not happy of what some people, for hiding what had happened in the Catholic Church, what it's done to families to this day. It has destroyed someone in my family. It's destroyed friends of mine that to this day, they don't have a life anymore because it has killed them. We had a friend commit suicide over this matter, and this is all in one town, in one parish. I can't understand why we as legislators cannot stand up for the very people that we said we were going to stand up for. There's 90 of us, 60 in the House and 30 in the Senate. And I put it out there to each and every one of you. I do not care what organization you're involved with. This is not about the organizations. As I'll state again, I am a proud Catholic, but I'm unhappy of the cover-up they've done for what has happened to young individuals and any other organization that has had any cover-up. And I stand here and I beg you guys. We were so ecstatic about this bill being heard on the striker. I couldn't sleep last night. I called Representative Espinosa, and we tossed and we just talking and belting out all the names of the people that we're going to be proudly here for and fighting for. We went on retreats with these people. We were side by side. In Clarkdale, Arizona, we were side by side with these people. And here he and I are, fighting for our friends. Fighting for the ones that we were next to and we couldn't help. Because our friends would not open up to us. It took too long for it to happen. And I hope it doesn't take that same length of time to get something done within this body or the body that I'm associated with across. I beg and plead to you guys to do something. And I don't care of the individuals that are in the hierarchy because, you know, individuals have hid this way too long, and it's time for us to step up to the plate and get it done. And again, it's not an attack on any organization out there. It's going after the perpetrators and making sure that they pay for the lives they've stole from these young individuals. I'm done, and I'll stand for any questions if anyone has any.
Thank you. Yes.
Thank you, Madam Chair. Thank you, Senator. Appreciate it. I just got something just kind of going through my mind. Why hasn't this been taken care of? I've been down here 4 years. Why now? Do you know? I mean, I don't know if anybody can answer that.
Representative Kern,
why didn't we take care of this a long time ago?
Madam Chair, Representative Kern, that's a very good question, and I'm glad you state that. I'm in the minority here. I'm used to things not being done. I had to fight for things to be done. This is my 7th year here, and I had my first bill signed this year. We have a Republican running this bill and has run it, but it won't. The body will not give it the time of day to get a hearing. And then when we finally get a hearing, we all know what happens, guys. I'm not going to stand on this mic and A, impugn anyone, or B, trash a fellow member. But we know what happens here. And I'll proudly say it on this mic with that camera on me. It's up to us members to make a change and get it done. It was here. It shouldn't have taken this long. It should already be in the books. But Representative Kern, it takes us to get this done. We can show you. We can show you the paperwork from when it was dropped the first time. It's been out there. It's been out there, and that's a great question. I hope that you're one to help us champion this issue and get it done.
Senator Boyer, did you also want to answer that too?
Madam Chair, Representative Kern, we had the votes. We got this out of Senate Judiciary last year. And then we were told, I wasn't told anything. President Yarborough refused to meet with me on this, on why he refused to put it on the board. What I've found and what I've seen in other states is anytime we actually get a vote, the votes are there. It's just getting it on the board, which, as you know, with tough legislation, that's always the difficulty as to why previous legislatures. I didn't know about the issue until all the publicity surrounding the Larry Nassar case. That's when I started doing some homework, and I realized, oh my gosh, Arizona's the worst in the country. And honestly, I think members just are unaware up until this point because hearings have been few and far between, which is why I'm so appreciative of the chair for even allowing a public hearing.
Madam Chair.
Yes.
Thank
Mr.
you.
Toma.
Madam Chairman, Senator Boyer, so first of all, I'm supportive. you and I spoke about this, and I'm more than supportive of trying to do something. And I think it's past due, in short, doing something here. I guess my question, just to clarify, there has been, and you and I talked about this a little bit yesterday, this bill has changed quite a bit. I know when it was first brought to me, it was different than what it is now. It sounds, based on a few of the statements you made earlier, that it's perhaps different than even what you and I talked about yesterday. So what exactly are you proposing in the bill at this point?
Madam Chair, Representative Toma, what we're proposing in the strike all amendments is 12 years from the age of majority where a victim can come forward, so that basically the age of 30, but also giving current victims who are time barred today a 1-year window where they can put forward a claim against their perpetrator.
Thank you, Madam. That was the part, the 1 year you mentioned. I wasn't aware of what that would be, but thank you. Appreciate it.
To that point, Madam
You may.
Chair. Thank you. And I do want to say that the bill was, I guess, from what I had heard, Senator Boyer, is you and another member in the Senate agreed upon the age of 25 and did not agree upon the 1 year. Could you go into that? Because there was an agreement to run the bill, from what I've heard. Want you to just respond to it. If you want to talk offline, we can. But that's what I've heard, and could you respond to that?
Madam Chair, Representative Kern, there's only been one agreement.
Okay.
The agreement was 7 years from the age of 18 or the age of majority and a 2-year window. That's been the only agreement. And that wasn't violated on my end. That was violated on the members' end that you're thinking of, that you spoke with.
Thank you.
Questions?
Madam
Representative
Chair,
Fillmore.
yeah, Senator Boyer, I'm the old guy left in the dark, and then usually they'll come up afterwards and they'll tell me. But I have to ask, this is a good bill. And I see no reason that the bill was not being heard. And I don't care about that the bill has changed. Every bill that seems to come through the legislature this session here, when I'm here, seems to be changing almost weekly just to try to move it forward. And I understand bills trying to be moved forward, but I'm missing the scenario as to why this bill, to me, is being killed this session today, is now, as I came in prepared to be supportive of the bill. Because I agree that when a little kid, or child, male, female, whatever, is abused, and they're under the confines of that person that is doing that until they reach the age of majority and they can free themselves and run away, and then find out that they don't have an opportunity for, and there is no equity for these kind of crimes. To me, I have said, and I will continue to say it forever, I believe these kind of crimes are capital crimes, and people say I'm too harsh, and I don't care. But I have to tell you, I'm sitting here today, and I'm dumbstruck that this is done. And I know it's the a decision of others that can do it. But I'm just trying to, can you explain to me, is this an issue between a promise that someone thought was made and then they thought wasn't? And you're talking between 25 and, in my mind, when they turn 21 in 1 year or 21 in 4 years, who cares? Who cares? Can you explain this to me? Because, again, I'm the person that's just kind of scratching my head.
Madam Chair, Representative Fillmore, as am I. I think that the opposition is grasping at this point because they know that they have no standing on the issue itself. And so now they're trying to make up a process or a protocol issue or some ridiculous notion that there was some agreement made, which there wasn't. There was one agreement, and that was for a 2-year window. And then I got a call from that same individual 2 hours later and said he had unagreed to it. But again, that's not the point. The point is we have good policy before us that we need to move.
Madam Chair, Senator Boyer, then why aren't we hearing the bill?
Mr. Fillmore,
Madam
as I
Chairman,
explained in my first comment,
I'm sorry,
there-
I must have missed that.
you must have. My first comment was that we are hearing this for discussion today, we're not moving the bill, and we're not moving the bill because there are some issues that we've seen because of last minute drafting and doing the things that we're doing.
Madam Chairman, so I can understand, please, I'm not being argumentative, but can you explain to this senile old guy what those issues are, so I have an understanding why
It's
an
more
issue
with
that's
the
as
window,
important as
Mr.
this-
Fillmore, and as we start getting into testimony, I think you'll kind of see that there are some issues going back and forth with the window.
Madam
And
Chairman, I will be
I
quiet for the
actually,
remainder of the,
I
bill
actually
presentation.
increased the age that was from the original deal was from 25 to 30. Mainly, I did that because I think of my own children. One daughter probably would have came to me when she was immediately happened. The other one I might not have known about until she's 29 years old. And so, we just don't know what our kids are going to do. So I felt the 30-year was and they say your actual brain doesn't finish forming until you're 25 years old. So if you do 25, I just didn't feel that was far enough. I thought we needed to go up higher. But the window, we have some issues with going back with that part of it, and that's the part I want to tighten up. Representative Kavanaugh. Oh, you're okay now? Representative Fernandez.
Thank you, Madam Chair. I have a question. Whatever side you are on this, I'm just wondering why we just can't vote on it. And I know it's for discussion right now. Yesterday we had a bill that I said I didn't think was ready, but Mr. Toma was able to work with the agency to fix the bill, and we went ahead and voted on it and passed it, even though it really wasn't ready. So I'm just wondering why we just couldn't vote on this, and if there's some tweaking that needs to be done, then certainly I think you would be up for that. Am I correct? Mr. Boyer?
Ms. Fernandez, since I'm the one that made that decision, and I think that probably should be addressed to me.
Oh, I started with you. I'm sorry.
That's okay. It would be, since we already announced that it is up for just discussion, it's a violation of the open meeting law right now to be able to even do that. So, but I put it up for discussion today. I felt like that even if it's not ready, and I don't feel it's ready, and so at this point, I wanted testimony so it's out there so that we can work on it, and it's public. So this is something that we will continue working on. Mr. Boyer and I will continue working on this. We're not stopping today.
No, and I appreciate that, Ms. Cobb. I just want to mention to you and to anyone else with just some historical information is I know that one of my representatives from, it had to have been at least 8 or 10 years ago, was here and they were bringing forth the same legislation. This was like 8 or 10 years ago. I'm going to go back and look, but this isn't something that just came together last night, Mr. Kern, to your question. They have been working on this. And
Ms. Fernandez, this strike everything just came together.
No, I understand. I'm just saying
so
this
it did
issue.
just come together. This issue has been out there, but we got to get it right. I want it right.
Oh, absolutely, Ms. Cobb, I understand, but I just think we have the ability to get it right and still vote on it. My opinion as a legislator.
Dr.
Thank you.
Freese.
Madam Chair, thank you. Mr. Boyer, I really appreciate what you and Senator Contreras are doing. I guess I didn't really understand the magnitude of this until just now. And I'm just astounded by what's unfolding. And I would like to suggest to you that you are absolutely right. There are people in positions of authority that can stop things dead in the tracks. But there are rules that allow the body to exercise its will. And, in the minority, we have attempted to exercise those rules. And I will sit down with you and help you understand those rules so that you can use the will of this body to get around these people with the positions of authority that are stopping the progress. There are ways to bring issues to the floor immediately, waiving the rules and bringing bills for consideration of the body. And if you feel the body has the political will and the Constitution to pass this issue, which I hope you are right, I would suggest that you consider those options. And one further question, Madam Chair.
Okay, if there's a question there.
I do not see on the agenda that is posted that this bill is for discussion only. Is it within your
It
purview?
is in my purview. Yes, sir. Mr. Roberts?
Madam Chair, just a comment. I just wanted to say that I'm not as well seasoned as Mr. Fillmore over here, but I too am just as befuddled as to what the opposition is to this bill. I came in here today prepared to support it. Maybe it's just because I'm a freshman legislator that I haven't been approached by the opposition, but I support the bill. Thank you for bringing it forward, and I look forward to continuing to support this issue.
Madam Chair, may I comment?
You may.
Madam Chair, Representative Roberts, absolutely. And that's what we found, is anytime we can actually get a vote, we have the votes. It's just a matter of getting it either in committee or on the board.
Representative Kerr?
I can comment. Well, I'll comment now. Thank you.
We've got other speakers here, too. We
Yeah,
wanna
just
make
a
sure
real
that
quick
we're-
comment on
we're
Madam Chair. There is,
respectful of them. Okay.
I don't think there's anybody, including the Senate and the people that are, quote, in opposition against this bill. That's not what I've heard out there. I have heard that there might be some disagreement, maybe on the timeframes or whatever, or so, I guess in the email that was sent out last night that you referenced. But there is nobody that has said they're in opposition or would vote no on this bill. So I want to make that clear. Whether you're a majority party or a minority party, nobody has said they're against what we're trying to do here. What they have said is there is a disagreement in the time frames. So just want to make that clear.
Madam
Thank you,
Chair, to that point,
You may.
if there was no opposition, we would be voting on this bill today, and this bill would have already made it out of the Senate.
Thank you.
Additionally to that point, there are avenues available to amend a bill post-committee. And if there's persistent disagreement, that can be addressed with a floor amendment. I suggest we move this bill out of this committee today.
We cannot do that. I already told you that, Dr. Freeze. So you keep saying that, and that's not something we can do. It's not going to happen today. But I would love to hear from speakers. Thank you, Senator Boyer, and thank you, Senator Contreras. You're both going to stick around so we can ask questions? Okay, thank you. Megan,
Wishing to speak for the bill, Megan Dellartino.
thank you.
Hi, Madam Chairwoman, members of the committee. For the record, my name is Megan Dellartino. I'm here on behalf of the Victims Policy Institute. I'm going to read what I wrote because I think it's important, but first I want to
Yes, please.
say, just with utmost respect for the chairwoman for allowing us to hear this really important issue today. I want everyone to know that I didn't know that the statute of limitation was 20 until I got a call from a friend in DC when they were looking at the Nassar gymnastics case. And they were looking nationwide at our statute of limitation from state to state. The friend grew up in Arizona, realized that Arizona has one of the lowest, we're tied actually for 50th in the nation. So if you are a child victim of rape and you live in Arizona, you have less time than if you are a child victim of rape in 47 other states that you live in. To me, that is atrocious. And so ever since then, March of last year, I've been working on this bill. I think the complacency in doing something is just because we didn't know. And you don't know. You don't look at laws until it happens to you or happens to somebody that you know. Do you look up, okay, what is the law? You don't know that as a child. So with that, in Arizona, we do not give victims of childhood sex abuse the time needed to find their courage and inner strength to speak out against their rapist. The bill before you today is about giving victims the time they need to process the painful memories of someone they trusted, yes, trusted, who violated them so deeply. Children are getting sexually abused today by the same predator that abused a child before them that is now an adult. There isn't a town in Arizona that is immune, including my own. It took the death of my brother, he was 15, and years before, others would speak out. That coach was later found guilty in a court of law. This bill doesn't affect me or my family because he is the victim and he is no longer here. But I do know that that perpetrator is walking the streets with a tattoo of my brother's face on his arm. Think about that for a second. This bill is about time. What is the appropriate time for a victim to have the opportunity for justice? This is a hard question because the long-term effect of childhood sex abuse are varied, complex, and devastating. There are no two individuals that process these abuses the same. All I know for sure is it is ridiculous to believe that 2 years, that by the age of 20 is enough time. This bill gives victims their voice back that has been arbitrarily taken from them. Yes, arbitrarily taken from them by Arizona state law. It doesn't give them that voice forever, but until they are 30 years old. Hopefully, that is enough time. Hopefully, their courage to come forward saves another child from the same abuse they endured. There's been much debate over what we refer to as the 1-year window. Why is that so important? A child rapist have an average of 14 victims before they are brought to justice. They do not stop raping children until they are made to. In Arizona, you don't have to silence someone forever. You just have to silence them for 2 years. We are a hunting ground to allow these predators to prey on our children. Allowing an adult to come forward prevents future abuse by the same predator. It is the only way we can take predators out of circulation who are continuing to abuse children today. I want to be clear. The burden of proof is on the victim. And nationwide, there hasn't been a single case, not a single one, that was brought forth frivolously. There's been claims that what about frivolous lawsuits? There's statutes in Arizona that protect against that. But again, I want to say not a single one has been frivolous that have been brought forth in other states. There's over 10 states who have passed similar laws with this, on this subject. We aren't changing our court standards in this bill. We aren't changing the standards at all. This is just about time. Negligence, which is in this bill, is currently a part of the personal injury statutes. We aren't adding institutions under this bill. They are currently a part of the personal injury statutes. All we are doing is giving more time. Predators don't stop until someone is brave enough to stop them. Let's give them more time to be brave. I've heard this will increase insurance premiums. It'll shut down churches and nonprofits. But again, in the states who have passed laws like this one, insurance premiums haven't skyrocketed, nor has any organization closed its doors. I've also heard, why don't you just focus on criminal statutes? Well, only 30% of those abused that are reported to law enforcement ever get prosecuted criminally. Why? Because children don't know that they should have saved their panties. They don't know that they shouldn't have bathed afterwards. That washed away the physical evidence. I've heard, well, childhood sex abuse could just be accidentally touching someone. Let me be clear, and I know Representative Toma asked this question. In Arizona law, sexual assault is defined as sexual intercourse or oral sexual contact with any person without their consent. This is not, I just accidentally touched somebody's bum. There are a lot of issues that I work on down here. This is my 21st session. I know I look a lot younger. I cannot think of one more important than the one that's before you today. I was nervous coming into this committee because I just feel an immense responsibility to these victims. And I'm just happy and proud that Representative Cobb has given us an opportunity to discuss this issue. And I'm honored to do so, and I'm sure that my family is proud of me for doing that as well.
Megan, thank you. I know how hard this is for you today.
Happy to answer any questions.
I would love, anybody have any questions for Megan? Thank you. Thank you so much. Who's up next, Mr. Toma? You could do 4 or
Joelle Cass. I'm not even going to try that. Please introduce yourself for the record. Thank you.
Good morning. For the record, my name is Joelle Castex. I'm an advocate for other adult survivors of child sexual assault like myself. I become one of the leading national spokespeople for behalf of victims. In fact, I came to Arizona 10 years ago to testify on a similar bill like this. This has been a long, hard fight in this state. As a teenager, I was sexually assaulted by the choir director at my high school. He deliberately targeted me because I was vulnerable. He knew I was powerless. I yearned for mentorship and a strong adult figure in my life. I did not yearn for an adult to sexually assault me. During the 2 years he targeted me, I was the subject of repeated sexual assaults and rapes on school property and elsewhere. By the time I graduated high school, I was pregnant and had a sexually transmitted disease. And like most victims, I lived with the crippling shame and secrecy for more than a decade. But because of a civil window, I was able to expose the man who abused me when I was ready to come forward. He was hiding in plain sight, working in a university, running a children's theater, and living in a state with predator-friendly laws. I was also able to expose the documented cover-up, showing that school and church officials knew for more than a decade that this man had raped me and other girls. Arizona has some of the most predator-friendly laws in the nation, laws that I have been working to change for more than a decade. These laws allow child sex predators to hide in plain sight in Arizona's schools, Arizona's communities, and even Arizona's legislature. Instead of making Arizona attractive to sex predators, you can empower crime victims to use the civil justice system to expose child sex predators preying on children right now, and expose and hold accountable the institutions that foster and facilitate abuse. It's time to decide. Do you stand with child sex predators, or do you stand with Arizona's children? Thank you.
Thank you.
Thank you.
Senator Farnsworth.
Thank you, Madam Chair, members. I'm Eddie Farnsworth, Senator from District 12, and I'm probably the person that was talked about earlier on a so-called agreement. So I wanted to come in and I asked the chair if it would be okay if I testified, because quite honestly, much of what's being said is being distorted. I can say this: there is not a single person in this legislature that believes we should be protecting predators. That is absolutely untrue.
Thank you.
There is nobody in this legislature that believes that we shouldn't have some recourse either through the criminal law or through the civil law. That's untrue. There is nobody in this legislature that was trying to block the ability for someone to have recourse against an abuser. That is absolutely untrue. So let me take a moment, if I might, and set the record straight from those who are on the opposition, the so-called opposition. This bill that came, there were two parts. One of them had to do with somebody who was abused before they were 18, and the fact that we have a 2-year statute of limitations, and it would change that to a higher age. There was a second piece that would say we would have a window from essentially any time that someone had been abused, even if it had been 60 years later, that they could bring a civil. Now remember, this is only civil action. They could bring a civil action. This has nothing to do with the criminal side. The state can still prosecute. Nobody's going to be walking free because of this bill or not this bill. This is a civil action. This is someone being sued because they injured somebody else. Has nothing to do with the state bringing a criminal action. We have to remember that, because the hyperbole that's around this bill actually is confusing those two issues. So the question and the concern from those of us who expressed concerns about the bill, and I was one of them, was that when you open up a window for a lawsuit, a civil lawsuit, that can happen 30, 40, 50, 60 years after the fact, it brings concern about the viability of the information that comes. We have statutes of limitations because the farther you remove yourself from an incident of harm, the less likely you're going to remember exactly what happened, the less likely witnesses are going to be available, the less likely someone's going to be able to defend themselves. We don't have statutes of limitations to defend criminals. We have them to defend people who are innocent and their ability to defend themselves in an allegation. Again, remember, we're talking about civil, not criminal. Sure, I can pause, yeah.
Okay, because I think it's really, really, really important from what I'm hearing and what you're saying. Please, Senator Farnsworth, explain the difference. So you're saying, from what I'm hearing, is right now there is the state can file charges against anyone at any time on a criminal basis, right?
Madam Chair,
Yes.
But this is
Representative Kern, this doesn't have anything to do with the criminal side.
Okay, right.
So whatever the state can do now, the state can do after this bill. It doesn't change it. This simply deals with the civil side.
Right, to that point. That's what I'm saying, sir. If you could explain that for me, first grade level, explain the difference between what we can do now criminally and what this bill's trying to do civilly.
Okay, Madam Chair and Representative Kern, I don't want to get into the criminal side in detail because this doesn't have anything to do with that. Okay. Whatever the state can do now, they will be able to do afterwards. The point is this bill will not stop the state from going after somebody for criminal action.
And to that point, you're saying that the state right now can go after somebody on a criminal action, whether they be 60 and it happened when they were 10, or...
Madam Chair, Representative Kern, I don't believe that's the case because there are statutes of limitations. If we think that criminally the state should be able to go after someone, then we need to look at the criminal statute of limitations.
Okay.
This is a civil side.
Okay.
So that's why I said I don't want to get in because this isn't intended to address the criminal side.
Right. Okay, thank you, sir.
But my point is that this isn't changing anything for what the state can do. The state can go after a criminal under the current statutes. This is a civil action. So the concern is, how long do we allow someone to bring a claim after the fact, after the injury? What this bill purports to do is to say there is no limitation. It can be 90 years later, it can be 60 years later, it can be 50 years later. It doesn't matter if witnesses are alive or dead.
Senator, so you're saying that this bill now opens it up to 50 or 60 years later, there could be a civil suit and not a statute of limitations on the civil suit of 25 years?
Madam Chair, Representative Fillmore, the answer is yes. There are two parts. There are two parts. One part is increasing the age from the age of majority, which is 18, not 21. I heard somebody say 21 in a comment while I was listening. It's not 21. Age of majority is 18. This would increase it to 30 years old. The second piece is that it opens up a one-year window, I believe. It's 1 year.
1 year.
Where any age you can bring an action against someone 50 years later. That's the concern that exists. So let me tell you the process we went through, and then I'm happy to answer any questions that you have. But I can tell you the distortion of how this was dealt with was a distortion and is a distortion, and that's why I'm here testifying. I had no intention of testifying, Madam Chair, but I appreciate the opportunity. So when this bill came to my committee, it was assigned to Judiciary in the Senate, I expressed my concern about the removal or the window, the removal of any statute of limitations on the civil action. I still have concerns about that. But I said, I believe that the 2-year that currently is in law after the age of majority, meaning that they would be barred after 20 years old, is too short. Let's find something else. I didn't dictate what that number was. What I actually did was say, let's set up a meeting with prosecutor. Let's have a discussion on what's reasonable and reliable here. I couldn't make that meeting. What I told the sponsor is, you meet with the prosecutor, whatever you guys come up with, I will agree to. That meeting was 25 years is what was set. That came from the sponsor meeting with a prosecutor. I agreed to that. Said, that's fine, 25, we'll do it. We took out the window. The agreement that he said that I broke is kind of a distortion as well. And I say this with all due respect. I respect Mr. Boyer. I think his heart is in the right place, but his recounting of the facts are far different than mine. I was on my way to a meeting that I was late to in the hallway when I was approached by Mr. Boyer and someone else, I won't use their name, and they wanted me to agree to a 2-year window, which I thought they were referring to the minor when they come in and reach age of majority. So 25, I thought we were going 2 more years. I finally agreed. I said, look, I have to go. I'm running late. Let's discuss this later. Continued to push it. So finally I said, okay, look, we can do an additional 2 years. That was what I thought. There was no meeting of the minds. I misunderstood what they were doing because I was in a rush and expressed that. When I found out what they actually were doing and what they thought we had agreed to, I called him immediately, and I think his testimony was within 2 hours I called. I called him immediately and I said, we didn't agree on anything because we were talking about 2 different things. And so, no, I don't agree to the 2-year window, which has to do with the removal of the statute of limitations. I said, but let's move forward with the bill for the 25 years. I put it on my agenda. The night before we were supposed to hear the bill, I got a call. I was told, I want you to take it off your agenda. Asked him if he was sure. He said he's sure. He said he believes that the bill's worse than what it is now. I said, I don't know how, I don't understand that. This actually adds what someone who's a minor can do, and in the time frame going to 25 years. And he was insistent that we stop. I said, okay. He wanted me to have testimony. I said, no, we're not going to do testimony if there's not a bill. So he said, let me call and I'll get back with you. I never heard back from him. Now, again, I'm not saying this to disparage anybody. I'm saying it to give you from my perspective. So here's what happened. I also met with a psychologist who was very experienced in this arena, talked to her while the speaker was in the room, and asked her about this, and I said, what do you think about the 25-year, or the expansion to 25 years? She said, that seems very reasonable to me. If you don't believe me, talk to the speaker. He was in the room. So that's the way this happened. I was ready, willing, and able to give it a hearing. I was willing to live up to the agreement that we had. We can differ on whether we think the policy is good or bad. There are people who will think that there shouldn't be any statute of limitations. That's fine. That's what this process is. But I was ready, willing, and able to hear the bill. I did not take it off the agenda except by the request of the sponsor. So, Madam Chair, again,
Do you have a question?
my position is removing the statute of limitations, absolutely, and giving a 1-year window. What that does is it removes the idea of justice. It removes the idea that somebody who's innocently accused has a very, very difficult time defending themselves. That's why we have statutes of limitations. Remember, this doesn't affect the criminal side. The state can do what it does under the laws that we have created. But on the civil side, I think it is bad policy. I don't think it's a matter of justice when you remove any statutes of limitation in a civil liability case. And so that's why I have been opposed to that window, but not moving the age from 18 to some later age. So, Madam Chair, I appreciate the opportunity, and I'm happy to stand for questions.
Dr. Freese, you had a question of Senator Farnsworth. I know Mr. Boyer wanted to come up and respond a little bit, but let's let these questions go, Mr. Boyer. Okay.
Madam Chair, thank you, Senator Farnsworth. You have some concerns about the statutes on civil liability, and I think that's a valid concern. However, I think we need to take into consideration some special circumstances when someone is harmed at a young age, when someone is harmed in a way that they may not wish to disclose for a period of time. And my question to you is, in a civil case, isn't the burden of proof on the plaintiff to prove harm? And if they can't produce that proof because it's been 40 or 50 years, that is the system protecting that potentially innocently accused person. Isn't that your concern?
Madam Chair and Representative Freese, absolutely. But the burden of proof is relatively low when you're making an allegation, and then the burden of proof shifts to the person who has to defend. So if you have someone who's innocent that is accused of a crime, and it's 50 years later, and the people that they worked with or the people who could testify have passed away, the documents have been shredded on, for example, policies and protocols that are established within an organization to make sure that people are protected. Are there two people that should be in a room when an examination is going on? Is that part of the policy and process that's established? That's some evidence. If that's all been destroyed 50 years later, how do you present that? If you have somebody who was actually in the room that has passed away as a witness, how do you prevent that? We're not talking 5 years after the case, Mr. Freeze. We're talking about potentially 30, 40, 50 years later.
Again, to that point, back to Madam Chair, Senator Farmers, back to my original question. If the proof has been shredded, discarded, someone has been deceased and has not given an affidavit, that burden of proof is on the burden is on the plaintiff to show, and the system will say, "I'm sorry, but your proof is not there." Won't that protect that innocently accused defendant?
Madam Chair, Mr. Freeze, what is required to present proof in an allegation? The allegation itself.
I'm not a lawyer, sir. You
the
are.
allegation itself is proof. If you have a second person, that's proof. Anything above that is proof. So the burden of proof in allegations are the allegations. Now the defense has the opportunity to defend, and if their evidence is not around, and that's what happened. Why do we have statutes of limitations at all? It's for this very reason. Because the farther you are removed from an incident of harm, the less likely that evidence is going to be valid. It's not going to be free. It may not even be existent because people shred documents, because people move away, because people die, because people don't remember. 40 years later, somebody will say, yeah, I think we did that, but I don't remember that specific case if we went in together. That's the problem. Memories become fuzzy. Evidence is lacking. That's why we have this isn't unique. This isn't unique to this issue. Statutes of limitations exist to protect against people being accused and being unable to defend themselves.
But I'm suggesting, Madam Chair, to that point, I'm suggesting that there are special circumstances when we apply statutes, and I believe that this would represent a special circumstance where we shouldn't be applying them, where we should be allowing the leeway to let that statute be longer than it would be for another circumstance. Meaning, someone was harmed as a child, and that person didn't recognize they were harmed until they were old enough to understand what happened to them. And then on top of that, there may be a period of time for that person to be ready to accept that happened to them and confide that happened to them, and confide in the system very publicly that happened to them. I'm suggesting that, I hear what you're saying, statute of limitations have a purpose, but there are always exceptions to every rule.
To that
and
point.
I'm proposing that this would be an exception.
To that point.
Mr. Kavanaugh?
Representative Freese, what is a reasonable time? I mean,
I
because
think-
under the one-year rule, it could be 50 years. So what is a reasonable time?
I
Because I'm
think
struggling with
that's
that.
our charge as a committee, and that's our charge as a
Representative
legislature.
Freese, that's what I want to tighten up.
Yeah. So-
Okay, that's my issue, and
To
it's
that point,
not
I'm saying,
something.
Madam Chair, there's still time.
Right.
We
No,
can vote
there-
this bill out of this committee today. There's still time to tighten that up.
To that point, are you comfortable with no limit, or would you prefer to see something come out of this committee that has some mid-ground limit?
Mr. Kavanaugh, I am comfortable with this strike everything as it is now, and I am comfortable voting this strike everything out of this committee today, and I'm comfortable with working on language to tighten it up with a floor amendment. We have many people in this room who are committing to work on this. Why are we dropping it now? There is time left in this session to deal with this.
Senator Freese, I have offered to take the window out and just to have it at 30 years, and I was denied that. So that was why I held it.
I appreciate, Madam Chair, I appreciate that, hearing that, but my point is there is time left in this session to deal with this. And there's mechanisms through regular order to deal with this.
Representative Roberts.
I had my hand
Madam
up.
Chair, I just wanted to make a comment to Senator Farnsworth to thank you for coming over and providing clarification on the reasons behind the concerns and everything. To my statement earlier, as far as opposition, I was referring to any outside opposition, not necessarily internal, but I appreciate you taking the time to come over here and provide clarification. I never wanted to insinuate that when I used the term opposition that there was any member that was opposed to working on this issue. But obviously there's always nuances in a bill that needs to be explored, and you've brought up a valid point. So thank you for coming over and providing that explanation.
Thank you, Madam Chair, Representative Roberts. Again, I'm happy to answer any questions. I would like, if I may, Madam Chair, Mr. Freeze, I respect that you believe that this is a good bill. That's fine. I'm not going to disparage or castigate or even argue. I've laid out what I believe is accurate. The chair in the House had the same concerns. The principle of statutes of limitation exist across the board for a reason. Now, if we don't think statutes of limitations are valuable, then we ought to have that debate, because this wouldn't be the only circumstance, in my opinion, that we would want to get rid of statutes of limitations. But we have to look at the underlying reason why they exist. And they exist. Our penal system is not to protect guilty people. Our penal system is so that we don't accuse an innocent person and shoot them before they have the ability to defend themselves. That's what we do. That's why in criminal cases we read Miranda rights. We appoint an attorney if they don't get one. We have an appeals process that can last for years. That's the criminal side. But the underlying principle is the same. People have to be able to defend themselves in an allegation. When you remove all time limits for an allegation, you have removed that ability for a reasonable defense, and we are simply saying, you know what, that's too bad. We think that this kind of a crime is so heinous that nobody gets or has the opportunity or the right to defend themselves. That's the way I see it. You can just disagree with me, which you do, and I respect that. But I stand by my statement that this goes too far, because now we ensnare people that can't defend themselves. So do we need to move the age? Yeah, I've already said I support moving the age. The 25-year age, that was agreed upon, checked with a psychologist who's very well respected in this industry, was told that that was reasonable age. So this wasn't something that was just plucked out of a hat. But I understand that reasonable people can disagree.
Thank you. Any other questions of Mr. Farnsworth? Mr. Kavanaugh.
Thank you. Just one comment.
You did too.
Oh,
Well,
you were
I
first.
asked.
You-
Okay,
Yeah, I think
yes,
I
you
was.
were. Yeah, I thought you were done because.
Oh, no, I'm not going to be
Okay.
done for a while. I hear the I thought, and I asked about taking this off. In my limited time here of 5 years at the legislature, I have seen bills leave committees that are half-baked, that amendments are put on the bills that need changes, and we vote on it as a body, whether the amendment should go on or not go on. If you thought that maybe 25 years was good, then why didn't you have an amendment to that? Why can't it leave the committee and then go to the floor and put that on there, put that amendment on there? I don't understand. And then Ms. Cobb, with all due respect, you said that you would take off, or I'm not sure what you said, but you would make a change. And I'm just
With the
wondering why.
window.
With the window,
With the
why
window.
aren't we voting on that change? Why wouldn't you
Because
bring
the
it forth?
sponsor did not want to do that. So the way the bill is the way the sponsor wanted it. He actually, they wanted a 7-year discovery also in there. This was negotiated originally. I was like Mr. Farnsworth, got a little bit taken back with the window. I thought the window was just extending it for a few years. Then when I realized that the window expanded it to where somebody at 90 years old could be suing, and it also there's a part in here about institutions too. So that, and normally it doesn't ever go to court because oftentimes these cases are settled, as has happened in California. When they did the window, there is a big time frame. So I wanted to kind of work on that window, and I don't feel that we could do it with just a simple amendment. And so that is why I wanted to work on this with Senator Boyer. And I said I would give it a hearing today, but that I wanted to work on this. I've also worked with Senator Farnsworth and feel like that there's something that, I mean, there's something maybe we can do to make it better, but it's not the way it is written today.
Madam Chair, if I may respond to her question. Madam Chair and Representative Fernandez, if you will recall in my earlier comments, I said I was ready, willing, and able to hear the bill. I didn't take it off except that the sponsor asked me to.
I'm still waiting to hear from Mr. Boyer on that, but thank you.
Oh, well, Madam Chair, I am confident. Mr. Boyer is going to tell you that he asked me to take it off. I don't think he's going to deny that. So I took it off at the request of the sponsor. He decided he didn't like the bill the way it was drafted. He asked me to take it off. I removed it. So that's why we didn't hear it in the Senate Judiciary.
I appreciate that, and Ms. Cobb, I do too. I do want to tell you though, and I don't know how long you've been here at the state legislature, but I know we had members here that said, why did this just happen? Why are we just running this bill? This has been, and I just heard from my representative that was represented before I was, over 8 years ago that we were talking about this very same issue. It's not something that just came overnight. And I'm just wondering, why weren't you more prepared then? Have you, when they brought you the bill and you made the decision to hear it or not hear it, that it had to be changed before you would hear it? I mean, was it new to you? Was the idea new to you? Had you? I just think we're getting away from, I'm asking you questions that I don't need to ask you. I think that the bill is here and we should vote on the merits of the bill. If we vote it down, we vote it down and we live with that and we come back next session with a better bill. Why aren't we giving the opportunity to vote on it? That's all I'm asking.
Madam Chair, Representative Hernandez, why wasn't I better prepared? We actually worked through this bill. We had an agreement to hear the bill. I put it on the agenda to hear the bill. Your question does not reflect the truth of what happened. So we did. As I explained earlier, Mr. Boyer met with one of the county attorneys. They agreed on a year. I agreed to it, and I put it on the agenda. Okay. So this wasn't something, again, that wasn't simply ignored. There was effort put into it, but because we disagreed on some of the policies within the original bill, we do what we always do. We sit down, we try to work it through, figure out what we can and can't, what we like, what we don't like. That's what we did. And then I even went to the point of talking to a psychologist to see what they thought about the 25-year, and I was told that seemed reasonable to them. So,
and Ms. Cobb, and I'm going to apologize to you. This is out of frustration because we see strikers come all the time like this, that maybe someone feels that, it's not ready, but we are allowed to vote on it. And we either vote it down or we vote it through. And if it needs to be changed, an amendment will be put on it on the floor. We see it all the time. We saw it yesterday.
Fernandez.
Madam Chair,
Ms. Fernandez?
Yes,
I'm sorry,
ma'am.
Madam Chair, if I may. And for me, here's the reason why. Because the sponsor, it's been an all or nothing. I don't want to speak for John Allen, but he, on multiple occasions, talked with Mr. Boyer about making changes and was told no. I met with the Speaker and Mr. Boyer. I won't go into that. The Speaker, you can go ask him yourself what happened in there. There have been a lot of efforts put in, and it's basically been an all or nothing. So to pass this out and believe that there's going to be an amendment on the floor, I don't believe it.
Yeah,
That's the reason. It's not because people aren't willing to work. It's because the other side has not been willing to consider changes.
Okay. Ms. Cobb, to that point, though, I just want to tell you, you're feeling our pain because we say those very same words. I don't believe an amendment will be put on this bill to make it better. We say that over and over again. Okay.
Mr. Freese,
fair enough.
just a minute. Mr. Kavanaugh?
Yeah.
Is this a new question?
No,
sir?
it's a new question.
Well, can
it
I
is
have
a
it
new
to that
question.
point?
To that point.
To that point, Mr. Farnsworth, if the amendment, we vote this out of committee, we send this to the floor amendment that you wish to see doesn't come on, this bill comes back to the Senate and you can vote no.
Mr. Chairman, Madam Chairman and Mr. Freese, I understand that. Thank you.
And Mr. Freese, Dr. Freese, we're working within our constraints here also. I got a message yesterday from you saying thank you so much for running through your bills and making sure that they're all vetted very well before they come to committee. Didn't you say that yesterday to me? This is the first one that we've had in this committee that I have felt that I have not worked through as much as I possibly could before it actually came to committee, so that you guys weren't put into a position that you didn't have to be in. Now, I gave the sponsor the avenue to have a hearing, and yet we are still sitting here saying you want to pass out a half-baked bill. When I have said I would not bring these bills to you unless they were fully vetted with me.
Madam Chair,
And so there are some bills that I have held that I didn't, but I wanted to be able to give him a hearing today.
Madam Chair, just if I may respond.
Yes.
I don't believe this bill is half-baked.
Well,
You may,
I do.
but I don't. And you're taking from me
and-
my opportunity to vote on it.
No, that's a purview of a chairman. If I don't feel the bill is ready, then I can put it up for discussion, Mr. Freeze.
I would like to change my new point to a
Yes.
to the point, so I can
Okay.
get the talk.
Quickly.
I just, thank you, Madam
Because
Chair.
I think we're
And
keeping
Senator Farnsworth,
Senator Farnsworth from his work in the Senate.
I just have, I'm just thinking that there was an agreement in the Senate to hear the bill in your committee. And, you know, many times I've ran bills down here where I wanted one thing, but I got another, and we worked on it through the process, and it didn't end up where I wanted it, but we voted it out. If this bill, and I believe it is across the board, everybody in this body and in the Senate agrees with what we're trying to do here, raise the age.
The limit.
From 25, and you even mentioned 27 in your understanding. Everybody agrees with that, so I'm just trying to think, why did we stop it in the Senate? Why didn't we vote it in the Senate and maybe even try to amend that on over here, the 1 year? That doesn't make sense to me. The 80-20 rule just does not make what we could have
Mr.
had.
Boyer, do you want to respond to that?
Well, let me respond to Mr. Boyer, Ken. I'll give you,
Okay.
Madam Chair and Mr. Kern. The reason why we didn't is because I was asked to hold
Right,
the bill.
exactly.
You can go and look at the agenda in my committee, and you'll see the bill was posted. I mean, this is everything I'm saying you can verify. And I removed it at the request of the sponsor. Now, I think he was very sincere in that. I didn't question it at all, other than I disagreed with his comment that he said this doesn't make it better, and I said I think it does. Right now, you have a 2-year statute of limitation, and this extends it for 7 years. So we disagreed on that, but I respected it. I said if you want me to do it, I'll do it. I pulled it off the calendar, and then in the Senate there weren't any other rumblings. In the House, it's been a full court press. So that's my side of it. You can ask Mr. Boyer. Again, I'm not here to castigate Mr. Boyer. I'm here to set the record straight on this side, because the testimony that I listened to while I was coming in actually was reflecting what I felt was an inaccurate picture of what happened in the so-called opposition.
Do you want to hear Mr.
I just have
Boyer's
one more
answer
question
first?
For the Senator
Okay.
Farnsworth.
Farnsworth, okay.
Thank you, Madam Chair. Senator Farnsworth, your sphere of influence is quite large. And I understand the purview you have over your own committee. I'd like to ask you if you had some influence or some advice for the House Appropriations Committee Chair on her decision.
Dr. Freese, we
Madam
did
Chair, I
have
don't-
discussion.
I don't know that that's relevant right now.
Yeah.
I believe it is, but you don't have to answer.
With respect to the chair, I'm not going to answer that, because she has the right to decide whether I agree or disagree. Well, I will tell you this. I feel very strongly that the chairman's decisions, you have to respect that. There's a principle of order and decorum that the legislature should have. I've been here a long time. I was here before I was elected official, and I can tell you the decorum has almost evaporated in the House. And that's a very sad thing. Just yesterday I was saying in 6 years the Senate will have no decorum. So that's unfortunate. There are people that are put into place that are gatekeepers. So the legislature is not intended to run bills quickly. If they did, we would have a unicameral system without a governor, and it would be just basically you vote and you get it out and now the law changes. The legislative process actually is intended to be the opposite. It's intended to be difficult and arduous and filtering, so that whatever pops out the back end is something that people agree to. Because what do we do in the legislature? One thing, We tell everyone in Arizona what they can and can't do by the force of law. So, for me, the chairmen are there, they are gatekeepers. Trust me, I've lost bills over the years that I didn't want to lose because the chairman chose not to hear them. I've never signed a petition to take those bills out of that committee. I respect the process, I respect the decision of the chairs, whether I agree or disagree. I believe Representative Cobb to be a good chair who's trying to do the right thing, and I respect her decision. So that's the best I can tell you.
Oh my God.
Do you want to respond to that before your question, or do you need a question from Mr. Farnsworth?
Well, I want to speak to
Okay.
Senator Farnsworth, but I'll have no problem waiting because I'm pretty good at that now.
Representative Boyer, did you, are you,
Honing your skills.
you
That's
want
great.
to, you what? Okay, and then, please.
Madam Chair, members, I didn't mention the senator by name earlier, but since he's come over and done something that in my 13 years down here I've never seen done before, maybe we're setting a new precedent where members can now come to committee and testify against other members' bills. Maybe that's fine. Maybe that's something we want to do. But we are here. It doesn't change the fact that Arizona is an outlier. We are. All the surrounding states that I mentioned, Utah has 4 years from disclosure. New Mexico has 3. California has 3. Nevada has 10. Or I'm sorry, 8. But now we're in this he said situation. There's been one agreement. And now that Mr. Farnsworth has come over here to testify and bring my name into it, I feel compelled that I can share his name and what happened. He's misremembered. He said it was in the hall. It was not. He was getting ready. The only agreement that was ever made was in committee, my committee on finance. He was getting ready to testify on one of his bills. I have a witness who was there who heard him say that he agreed to 7 years from the age of majority with a 2-year window. That's the only agreement that's ever been made. Yes, I did tell him to pull the bill, the crappy version. I did ask him to pull that bill on his agenda, and here's why. Because he made us commit to that we would never amend this bill, that was the only version that we were going to get. And I have some, and we still, by the way, we still have yet to hear from the survivors. We're here, it's 10:30, it's been an hour and a half. We didn't get a hearing over there. We still have yet to hear from the survivors, which I would like to hear from.
Senator
If I could just,
Boyer, I didn't put time limits on anybody's today because I wanted to give this as much time as you needed today. So if you're complaining about the time that we have, we could stop it right now if you'd like us to.
Madam Chair, I think we should hear from the
I
survivors.
would hope so too, but I want to give this issue as much time as possible. And I think that in light of what some of the colleagues here on the committee have asked, Senator Farnsworth heard what was going on. He felt it was a misrepresentation. He wanted to clear the air on that. I feel that his testimony, as much as Mr. Contreras' testimony they're both senators. They can come over here and talk for or against. But I gave as much time as I possibly had. He asked right from the beginning, we have a time limit every time, and I said no time limit on this one. I want to give it as much time as it needs.
Thank you, Madam Chair. Can we hear from Jeff Dion?
We can, if there's no other questions for Mr. Boyer or Mr. Farnsworth.
I've been waiting to speak to Senator Farnsworth.
Okay.
So before he leaves, I would like to speak to him.
Okay.
Question for Boyer?
Quickly, and then Mr. Chavette.
Thank you, Madam Chair.
Boyer.
I'm actually the special guest today. Chair of the Approach Committee.
Lucky you.
Aren't you lucky?
But Senator Boyer, I really want to thank you for your leadership and for your willingness to bring this issue forth. My question here, and one thing that I keep hearing, is the potential removal of statute of limitations. In your original bill and in the Strike Everything Amendment, is that your intention?
Madam Chair, Representative Chavez, my intention is to go after current sexual abusers today. And the reason why the window is a non-negotiable is because child victims, because of the trauma, the sexual assault, the psychological, the emotional, the physical trauma, it takes them sometimes decades to come forward. Now, Mr. Farnsworth mentioned one psychologist. I have multiple studies that they've looked at hundreds of victims, and the reasons why they delayed coming forward and how many years it took them to come forward. And most victims don't come forward until they're in their 40s, because that's the time that when they've been able to process and when they've been able to come to grips with what has happened to them. And so, but if we want to stop current perpetrators, because again, like we heard in testimony earlier, a child doesn't know that they shouldn't have washed their panties or that they shouldn't have showered, because now there's no more physical evidence to tie the perpetrator to the crime. And that's why, Madam Chair, these criminal charges rarely, if ever, make it to court. There's either lack of eyewitnesses, lack of physical evidence. The victim certainly doesn't want to come forward. They don't know what's happened to them. And so that's why we have to have the window. That's why it's so important. And so we just fundamentally disagree on that.
And Madam Chairwoman,
Yes.
and I completely agree to the need for decorum in this place, and of how that decorum defines the core value of this institution. However, when we've been going on a decade in talking about this situation, not much changes over the years. The issue is we are here to protect children. We are here to protect what they are going through. And if that means passing a piece of legislation in which we can somehow come to a consensus, and it's going to protect individuals in our communities, in the state of Arizona, that's what it's going to take. It's going to take political will from each and every one of us. But we need to get back to the real issue as to why we are here, why Senator Boyer is so adamant in that we talk, debate, and pass some sort of legislation that is going to protect these children. That's what we need to do.
Madam Chair, to that point.
You may.
Madam Chair, Representative Chavez, absolutely. And that's why the window is so important. You know, I've heard that nobody supports protecting and shielding sexual predators. That's fine. We can say that all we want. But you have a bill before you that actually in deeds, not just words, but in deeds, actually protects children. And that's why I'll leave it at that, Madam Chair.
Okay, thank you.
I have
Mr. Farnsworth, Mr. Kavanaugh's been waiting on a question, and then we could bring Mr. Boyer back up because he's going to have to, I think, take off here.
Madam Chair, if I can make a couple of points before you do. First of all, I'm not here testifying against this bill. This bill's not even being heard. It's not being considered. So I'm not here to testify against a bill. I'm here to set a record straight for things that were said while I was listening. If I may, secondly, Madam Chair and Mr. Chavez, I appreciate what you're saying. The point is, this doesn't protect children. The criminal law that says they can't molest children is intended to protect children. This is a civil action after the harm has occurred. So your analysis, I understand your passion, I appreciate that, but it's an incorrect analysis. We have criminal laws to protect children. This is a civil action after a child has been hurt. This bill will not prevent the harm to anyone.
Mr. Boyer, did you? Yes, to that point. He wanted to do that point.
Madam Chair, nothing could be further from the truth. Because, again, criminal charges rarely, if ever, get filed in child sexual abuse cases. The only way to stop a current sexual predator is through the civil route, because we know that predators don't stop until they're caught or they no longer have access to children. And the way to do that is to expose them on the civil side. And I have, again, some testimony that can further corroborate what I'm saying.
Okay, let's finish up. You want to ask Mr. Farnsworth a question? Mr. Kavanaugh?
Yes.
You just did. You don't have a bill being heard. It's not being heard.
Okay.
So they're not going to vote. There is no testimony against
Oh
your
my
bill.
God.
All right,
So,
Okay, thank you, sir.
thank you.
Senator Farnsworth, first, I appreciate your history in judiciary committees. I think when I came here, you were the Jude chair probably, and that was over a decade ago. And I also appreciate your gatekeeping role. I know about 10 years ago, you did a similar task on a similar controversial bill that got you a lot of very bad, undeserved publicity. So I appreciate your understanding the role and fulfilling the role of the committee gatekeeper.
Thank you.
There are some other, in terms of your legal mind, There are a couple of other sections of this bill that I had concerns about, but nobody's really raising them, so maybe they aren't concerns, and I would like your opinion, because if they're not an issue, then I'll forget about it. But I don't know why they're in the bill. The first talks about when a cause of action can take place. And it says, an injury that the minor suffers as a result of another person's negligent or intentional act if the act causes a cause of a sexual assault committed against the person. Is that just a restatement, in your opinion, of existing law, or are we lowering the liability level for civil liability down to negligent? Because I'm hearing the argument two different ways.
Well, Madam Chair and Representative Kavanaugh, first of all, thank you for the kind words. I have, over the years, taken a beating for trying to stand up for doing what's right, but that's okay. I will continue to do so. With regards to that, there is a reduction in what I would consider the standard. Negligence is far different. I don't know how you negligently, and I can be corrected, but I don't know how you negligently molest somebody. That generally is an action of intent. Negligently would be if you were negligent in moving and being too close to somebody and accidentally touching places you shouldn't be touching. That's what I would see negligence would be. But if I'm going to molest someone, that is an action of intent. I intend to molest them.
Yeah, and Madam Chair,
Yes.
the way
I probably shouldn't use I intend to, because I
concern-
don't. But it's,
the concern that was brought to my attention was this would be a situation where, say, a school teacher who is required to report possible abuse, right? That school teacher doesn't sees the signs but doesn't recognize it. They're negligent. They fail to recognize it as the signs of sexual abuse, so they don't report it. And then, because of that, a month or two later, that night, the child is abused again because they didn't call the authorities. So, the concern that somebody raised to me was that police officers, firefighters, paramedics, school teachers, counselors, I mean, the whole list of people who are required to report could be sued if they, out of ignorance or negligent, they failed to perceive it when they should have. Do you think that's an issue here, or is this something totally different?
Madam Chair and Representative Kavanaugh, I think it could be an issue. Yes. I don't have the bill in front of me, and I just learned about it yesterday. So so forgive me. There are pieces in there that probably I haven't studied very closely. But yes, if you're talking about the mandatory reporting, and there's an obligation for the report, and the standard is negligence, I could very easily see a claim coming. Again, with the window, the claim would come at any time 40 years later because a teacher didn't report because they didn't see it. Yes, I could see that being
and Madam
the
Chair,
case.
And related to that, the second one says it's a cause of action if a person who is supposed to report doesn't report. And I guess that would
Go with that.
kind of be on the same.
That, Madam Chair, Mr. Kavanaugh, that would be in the same vein as what we just
And
talked
I ask
about.
because, as discussions go forward, if those are issues, I think they have to be addressed too, because I don't think we should have school teachers, counselors, suddenly expose anybody who's supposed to be reporting to lawsuits.
Madam Chair and Mr. Kavanaugh, I do. I think that there are some concerns there.
Thank you. Any other questions for Senator Farnsworth? Do you want to answer this one? Okay.
Madam Chair, Representative Kavanaugh, negligence is actually taken from the current personal injury statute, so that's not changing. Arizona law, and to the second point, Arizona law, and you can look it up yourself, Title 13, 3620, we already have a mandatory reporter statute in law. I'm a teacher, and if I see something where I think a student, if I reasonably believe that a student has been harmed, then it's my duty, I'm mandated to report that. So we're not doing anything unusual. We just, the negligent question, we are just taking, again, from the current personal injury statute, and I have Jeff Dion who could further elaborate on the legal side.
And as the author, Madam Chair, I'm glad you're here. So are you saying that it is not your intention to expose to civil liability a school teacher who negligently didn't recognize signs of sexual abuse, didn't report, and then the next night or the next week, because there was no government intervention, the child was abused? That this Section 1 is not written to create that liability.
Madam Chair, Representative Kavanaugh, again, we already have, and I'll read it to you. You can look it up if you're online.
Yeah.
133620, subsection A. Any person who reasonably believes that a minor is or has been the victim of physical injury, abuse, child abuse, a reportable offense or neglect that appears to have been inflicted on the minor by other than accidental means, or that is not explained by the available medical history as being accidental in nature, or who reasonably believes there has been a denial or deprivation of a necessary medical treatment or surgical care, shall immediately report or cause reports to be made of this information to a peace officer, and then they mention who it should be
Madam
reported to.
Chair, that is not the case that I'm giving you.
Yeah, that's not.
Because that's not negligent. In that case, the person reasonably believed. This section says if the person should have reasonably, if a reasonable person should have reasonably believed, but they were not that bright and missed it, then they're negligent. So do you want a teacher who, because of whatever reason, distraction, they're not that with it that day, failed to see what a reasonable person would have? Is it the intent of this section to make that school teacher or counselor or cop criminally, civilly liable for any further molestation that occurs because there was no government intervention?
Madam Chair, Representative Kavanaugh, it's my intent for, and this is more for the organization, that they should have known or should have reasonably known that, for example, if they put a known sexual predator in charge of either an organization or something that oversees children, yeah, they should have reasonably known, and they were negligent in that respect. And yes, they should be held responsible.
What about, Madam Chair, what about the teacher who doesn't pick it up when a reasonable teacher would have, who made a mistake, didn't see it when a reasonable teacher should have, and then doesn't report it, and then the child is molested down the road because that teacher, do you want that teacher, is it your intent to have that teacher civilly sued?
Madam Chair, Representative Kavanaugh, no, I mean, this is already covered in state statute. And that's why we have the term reasonably believes in current statute. Again, Madam Chair,
Right.
I can have Jeff Dion who can explain that better than I am.
And I'm not saying, Madam Chair, that that's your intent, but I'm saying some of the problems is the wording. And maybe a lot of this wording has to be tightened up to make it clear that you're not trying to ensnare the teacher who misses something, but you're only trying to ensnare somebody who knows there's a child molester and lets them work anyway.
Madam Chair, Representative Kavanaugh, again, I believe that current law already protects the
Mr.
teacher.
Boyer, I read it the same way after Mr. Kavanaugh brought it to me, so it's not as clear as we would like it to be. Again, this is one of those things I felt that you and I could work on. There were several issues, but this was one of them. And so I don't think it's clear enough on this spot. Okay?
Madam Chair, I would love to work with you on this.
Representative or Senator Farnsworth, you had to add to that point? Okay.
Thank you, Madam Chair. I would just point out, again, I don't have the striker in front of me. I didn't intend to come in and testify. But the two questions that I would ask in analyzing that is, if, number one, what we are doing is we're expanding the statute of limitations even under the 30-year-old or the 25-year-old. So that is a change. Under the current statute, there is a much shorter statute of limitations. So the question that you have to ask yourself is there a retroactivity clause? If it is, and then you have a one-year window that opens up, you now have subjected somebody in the case that Mr. Kavanaugh is talking about to civil liability 40 years later if this retroactivity clause applies and if the one-year window is to pass. So the scenario you're talking about, the statute would change. It wouldn't be the same, even though they're using the language the same. It doesn't have the constraints, and that's what I was talking about. The constraints we have from the statute of limitations protect people against false allegations. If this falls within the scope of the retroactivity and the one-year window, it wouldn't. It would be different. The same type of language, but with now an unlimited amount of liability for 50 years.
Thank you.
I'd just like to make a comment.
Madam Chair, if there are no more questions for me, I need to go check in over on the other side.
I'd just like to make a comment about something the Senator said a few minutes ago.
Is that something you want me to hear, Madam Chair, Mr. Freeze?
You can hear it. You don't need to respond to it. It's not a question. But you did allude to the fact that there's respect in not challenging a chair's decision and stopping a bill that has the support it requires to pass. And I suggest that there are rules. It is not disrespectful as someone who has used those rules to try to get around a chair or the president or the speaker, it is not disrespectful in any way to use those parliamentary procedures to achieve the will of the body. Just a statement doesn't require a response.
Well, I'd love
Doesn't
to
require a
respond. It doesn't
response.
require one, but I'd love to give one. So if the chair will indulge me, I'm happy to
I
do
was
that.
expecting one.
Madam Chair, Representative Freeze, I don't disagree with you. The rules are what they are. That doesn't mean that you can't use the rules to destroy decorum. That's the point, is that you can use them and you can use them judiciously. I'll use an example. We can also call for the question. And I can't tell you how many late nights we had in the House because people wanted to continue to ask questions of their colleagues, knowing full well what the answer was. I discourage my colleagues from calling the question. In my tenure here, I've only done it twice when I felt like it was an absolute abuse. So my response to you, sir, is absolutely the rules are there, but that doesn't mean you can't use the rules to destroy decorum or to inflict harm on the institution. So with that, Madam Chair, I do have to go.
Madam
and,
Chair.
Thank you.
Madam Chair.
Thank you.
Madam Chair, I do want to say, may I reiterate, I have respect for Mr. Boyer.
know
My
you do.
intent here was not to disparage him or to show any disrespect. I respect him. We disagree on some of the issues here, but I respect what he's trying to do. And I have no negative feelings or sense towards Mr. Boyer. He's a good man trying to do good things. We just have a fundamental difference in policy.
Senator
So
Farnsworth, thank
Chair.
you so much for coming over and clearing that up for me. Thank you.
Madam Chair, real quick, I just want to say, I think we got way away from what we were hearing, and I think I should be allowed to say this because I just want to make sure people know and that our public knows. When we call for the question, or not so much call for the question, but Mr. Farnsworth talked about asking questions when we full well know the answers. That may be so, but our constituents don't know the answers. So many times when I'm asking a question, certainly we should never ask a question that we don't already know an answer to. But it's my constituents that want to know the answer. So that's why I asked the question.
Ms. Fernandez. Who's?
That's my problem. I don't
Karen,
know the answer. I have
No,
no-
you want Jeff to go next.
Oh, okay.
You would like Jeff to go
Jeff
next.
Dion.
Jeff, and I know we have some people here
Yep.
that are victims, and so we really would like to get to them too today. I know.
Absolutely.
Okay.
Madam Chair, members of the committee, thank you for the opportunity to be heard. My name is Jeff Dion. I'm the Executive Director of the Victim Policy Institute, which is the legislative advocacy arm of the National Center for Victims of Crime. I'm a survivor of childhood sexual abuse. I did not recognize that what happened to me counted as abuse until I was in law school. I was in my mid-30s before I recognized how that abuse had harmed me and what the impact it had been on my life. I'm an attorney. I'm admitted to the bar of the Supreme Court of the United States. I've been working on these issues around the country for the last 20 years. And yes, 8 years ago, I was here in Arizona working on a very similar issue. Senator Farnsworth said that we shouldn't say that this particular crime is so heinous that a person can't defend themselves. I think actually what the current policy says is that there is no crime and no evidence strong enough to allow a victim into the courthouse after the statute of limitations has passed. This is a good bill. The most important part of this bill is the civil window. Because we know that even if it takes someone 30 years to disclose the abuse, when their perpetrator is still alive, they're often still molesting kids. And I'm curious as to why Senator Farnsworth kept saying this has nothing to do with the criminal law, but he required Senator Boyer to go meet with the criminal prosecutor to talk about it if it wasn't relevant. Now, criminal law in Arizona, the criminal prosecution can be brought within 7 years of when the victim discloses to law enforcement, no matter how long ago it happened. If someone who is 70 years old goes to law enforcement and says, I was sexually abused as a child, under the legal statute of limitations, they have 7 years from that date to file a criminal prosecution.
To that point, I believe it's 7 years after the identity of the perpetrator is known.
Okay, so I come from a state in Virginia where we have no criminal statute of limitation on any felony. I've seen 30-year-old prosecutions for child sex abuse. Are they tough? Yes. Are they rare? Yes. But sometimes it can happen. Usually, and there's got to be corroborating evidence. There's usually, you have multiple victims. And but as was correctly stated, the burden of proof is on the victims to prove their case. In the criminal case, prosecutors have a really tough burden, have to prove it beyond a reasonable doubt. That's because if someone's found guilty, we're going to take their freedom away. In the civil case, the burden of proof is just a preponderance of the evidence. More likely than not, the greater weight of the evidence. And that's because, why do we have a lower burden of proof? Because we're not taking away their freedom, we're just taking away their money. And and that's why it's so important to have this window. And so, yes, there have been 9 other states that have passed civil windows, and for that limited period of time, you could bring a case without regard to the statute of limitation, no matter how long ago it was. But they have to be able to prove that case. And the weight of the evidence is judged by a jury. And so what we're saying is, even if someone has photographic proof or DNA evidence, we're not going to let them in the courthouse door to present their evidence once that statute of limitation goes by. We're saying that this is a unique situation, and that we should be able to, in this limited one-year window, let victims come forward, and then these cases can be dealt with on a case-by-case basis in the regular course of civil justice. They present their case. If they fail to state a case, the judge can dismiss it immediately. If he does think there's enough evidence to go forward, it can go to a jury and they can decide. Out of these 9 states, there have been thousands of perpetrators that have been identified and exposed. No, in those states where there have been civil windows, not one claim filed under a civil window has been proved to be false. 4 states that have opened civil windows had the constitutionality of those civil windows challenged. All of them were upheld. And it's absolutely critical that we include those institutions. He said, I don't know how you negligently abuse someone. The negligence is on the part of the institution that hires a pedophile to work with kids. That's what's negligent. Negligent hiring, negligent supervision, negligent retention. Perpetrators need the help of institutions to get access to children. And they make a point of volunteering or getting jobs working with kids so they can have that access to kids. These otherwise well-meaning institutions can't bury their head in the sand and pretend these people aren't trying to get in there. I'm an Eagle Scout. I loved scouting. It's a great organization. We just want these organizations to do better. And
sir, I have a question for you.
We've had a window,
hey,
they still have. Yes, sir.
You need to stop when I talk to you. I have a question for you. This is not lawyer. You can't go past me. Okay. According to what Mr. Kavanaugh said earlier about the negligence, because you talked about negligence a couple of times here, and that's that piece in there about the negligence. So if a teacher is unknowingly negligent, can she, under this bill, 30 years later, be brought up on charges or be civilly sued in this?
I don't think you can be unknowingly negligent because the standard is whether someone knew or should have known. Part of the standard of negligence is, first, there's got to be a duty. You've got to breach the duty. There's got to be causation, and there has to be foreseeability. That is an element of negligence that has to be
sir,
proved.
when you respond to me, you have to come through the chair.
Okay.
And then, okay.
Yeah, to the point, so I think the concern we have is that our cops, firefighters, paramedics, school teachers, emergency room personnel, right, if they should have seen something, if a reasonable person in their position should have seen it, but they missed it, then they're negligent. They have a duty under law because they're already mandatory reporters. So under this bill, in your opinion, would they be civilly liable if that child left the emergency room and was re-victimized because they didn't call the police or DPS to intervene?
Possibly. I'll give you an example
the
of
chair.
Madam Chair.
Mr. Kavanaugh.
Well, that's a good enough an answer, Madam Chair. My follow-up is, do you think they should be held civilly liable, especially many years later when it was just they missed it by mistake? Do you think that should be part of the law?
Negligence, Madam Chair, negligence is a mistake. I can give you a real-life case example. A 11-year-old girl, her mother brought her to the doctor because she'd missed her period. And the doctor said, oh, don't worry about it. 4 months later, she comes back. She still hasn't had her period. And I said, I told you not to worry about it. If you want another opinion, go see a specialist. And that afternoon, they went to see someone else and found out the girl was 7 months pregnant. She'd been repeatedly raped by mom's longtime live-in boyfriend. On the very first visit, the doctor had done a pregnancy test that had come back positive, but they didn't look at the result. And that doctor was charged with failure to report because there was a test that they did, and so it's based on the facts.
Yeah, to the point. So was the doctor sued?
Yes.
Okay. So in your opinion, then, if a police officer, a nurse, or a school teacher, right, should have seen something but missed it, and as a result there was no report made and the child was re-victimized, in your opinion, they should be civilly sued?
Depends on how egregious the facts were.
Well,
and that's
I just said there was signs of
possible,
sexual
yes.
abuse, and they didn't see it. They blew it.
It's possible.
Because that's of some concern, I think, to our teachers, also their schools, too. So I'm a little concerned about.
Well, and usually that
creating
happens
a lot
in
of.
Madam Chair,
Yes.
usually that happens in their official capacity. And so it would be a claim against the school rather than against the teacher personally.
Okay, thank you. Any other questions for?
Well,
you have a
I think I
question?
do.
Yes.
Are you recognizing me? Okay.
Yes, I am.
Thank you. I can't see
I know.
him.
I know.
Madam
his big head right here.
No, he's ready to go.
Had it my whole life.
Madam Chair, I just wanted to, you mentioned the criminal part of it about Mr. Farnsworth assuring that Mr. Boyer had to meet with the criminal attorney with the county. So is that a little strange if this had nothing to do with criminal, like he said?
Well, that's why I didn't understand that, why there was a meeting if this has nothing to do with
To the
criminal.
point, I believe he said the county attorney, which is also civil. No, I'm going to clarify what I
can he
thought
answer
Farnsworth
then?
said. I thought he said he had to meet with the county attorney, and the county attorney
said
is
the
also a civil
prosecutor said.
litigator.
Can you answer the question, although you were interrupted? Go ahead.
Madam Chair.
Yes,
Representative Fernandez. Yeah, I mean, in Arizona, county attorneys do both civil and criminal, but he had referenced the prosecutor. So
Absolutely,
Okay.
he did. Thank you.
Ms. Udall.
Thank you, Madam Chair. And I guess I kind of want to go back to an instance where maybe somebody missed something they should have seen, but then perhaps 50 years later, that organization they belonged to then is held civilly liable and sued. The people that now are in charge of that organization are not the same people that were there 50 years ago. The teacher or whoever it was, is no longer there. But yet that organization then can be held civilly liable 50 years down the road, even though it's under completely different hands and different people involved, different ownership perhaps. I think that's my concern with the window.
Sir.
Madam Chair, yes, that is correct. And it's an institutional liability, which is generally covered by insurance. And it's about the insurance that was in place at the time of the negligence. And as we said, the burden is on the victim to prove this, but oftentimes as we go through, they say there are no files. Most of the cases that have been resolved or have gone to trial where there's been liability is because there was evidence in the defendant's files that showed they knew about it and that they covered it up. So that's where the evidence is. This isn't just being made up. Well, it could have happened. And so, but yes, there could be liability, but that's something that's covered by insurance.
Representative Roberts.
Madam Chair, sir, so we've been sitting here for 2 hours now, and we've heard a lot of testimony from the sponsor, from Senator Farnsworth, from yourself. I'm just sitting here, and I have this question that I keep coming back to because you guys have said several times that the window is the most important thing. The window is the most important thing. But at the same time, you say that the only way you're really going to get a predator to stop is to stop them. So why did we not move the bill through the process without the controversial portion? Because obviously there's controversy in the aspect of the window as far as we're talking about negligence and the sliding scale of whether or not there was negligence, and how do you determine there was negligence, and then the statute of limitations portion. If we were to have put the bill through the process and just extended it 7 years, would we not be stopping people that are in the process at this point that are doing this? So you're saying that would not be a step in the right direction? Because it makes me go back to the concept of voting against something because it's not enough. And I think that's a ridiculous notion. I think that we're all on board with this, so why did we not move this forward and in the right direction?
Madam Chairman, Representative Roberts, it's not, and the fear is that if a minuscule increase in the statute of limitations would relieve political pressure and let elected officials say, oh, well, we just dealt with that. But it's sort of like if everyone's arguing, for example, that if people are arguing that the minimum wage should be $15 and it's currently $7.25, and you say, well, we're going to raise it to $7.75, and it really doesn't have that much of an effect. And also changing the statute of limitations only prospectively means that it only applies to abuse that happens after the effective date of the statute. And so if a 10-year-old child is abused today and we're going to give them until age 25, that means their statute's going to run in 15 years. We know that the literature and the studies show victims usually don't come forward till their average age is 47. And so when they're ready to come forward, that's when they're going to expose the perpetrator. That's what's going to draw attention to people and cause people, and when someone comes forward, then other people come forward, just like with Jerry Sandusky. One brave victim came forward, and then before you know it, there were 30 victims that came forward and said, yes, it happened to me. And so by allowing the people who are ready to come forward are the people whose abuse happened in the past. That's why we need the window, and that's why it's so important.
Thank you, sir.
Thank you very much.
Oh, one more question?
Yes.
Of him?
Yes. Thank you, Madam Chair.
Okay, because I'd love to hear the victims here.
Yes.
Okay.
Thank you,
Get
Madam
them
Chair.
out of here
Mr.
this
Dion.
morning.
He was a victim.
You that you've been working in this situation across the country, in the states where the limitation is longer, or the window is longer, statistically speaking, how many more individuals has this helped? How many more victims has this been able to help them?
Madam Chair, may I clarify? When you say do you mean a longer statute of limitation or a longer window? Because windows have ranged from 1 year to 3 years.
Madam Chair, Mr. Dion, a longer window.
Madam Chair, it varies. In California, where there was a 1 year window, there were probably about 800 cases that were filed that exposed about 300 previously unknown perpetrators. In Delaware, which had a 2 year window, I think there were about 400 cases that were filed, and we'll hear from someone that exposed an unknown perpetrator. In Minnesota, there was a 3 year window and about 1,400 cases filed. So I think it is a matter of the length of the window and the work done to let the public know about it and what victims' options are.
Thank you.
Thank you, sir.
Thank you very much.
Karen Annette Schuster. Karen Annette Schuster.
How many do we have?
Two more. Well, I will read what I have read, but
Karen?
It's been this.
Yes, please pull it down, and for the record, you got to give your name.
Sure. I'm Karen
And
Annette
who you're
Schuster.
representing.
I'm here as a survivor of childhood sexual abuse, a prevention educator, and an advocate for victims of abuse. So I will read what I've read, but it's interesting just sitting here listening to the debates. And I think Sometimes I hear us go back to remembering that we're really here to be an advocate for victims. And I'm hearing a lot that that's what I really believe each of you are wanting to do. But then it seems like we get lost in doing that with whether it's a 1-year window, a 3-year window, how it seems like we get lost again. And it's really reminiscent of me of why so many victims don't even bother to report, because they get lost. The system is challenging. It's, you know, often they're not believed or there's not enough evidence to do anything. And so it is a difficult system for victims to go through. And so just me being one who's been a victim and one who advocates for victims, it's a very similar feeling listening here to kind of the tug-of-wars that are going on to what goes on for a victim when they even consider reporting. So that's just a personal thing I'm experiencing here. So all who are here today are educated men and women. We know that 90 to 92% of childhood sexual abuse is perpetrated by someone the child or the family knows, loves, or trusts. And when sexual abuse is perpetrated by a close family member, like the mother, the father, the step-parent, sibling, grandparent, victims live with a sense of fear and hopelessness and powerlessness and confusion, which makes them absolutely certain that there's no one safe to tell. Sexual predators outside of the immediate family system are very similar to predators in the animal kingdom. They methodically study their potential prey. They set their trap by gaining the trust of the child and or the family or the institution. They move in and meet unmet needs. They provide love, attention, tenderness, special favors, or gifts. Once that trap is set, sexual violation begins. The predator uses their power to ensure their prey remains silent, confused, afraid, and compliant. At some point, their victim may begin to resist or someone becomes suspicious. The predator is alerted and disappears as quickly as they appeared, moving on to the next child, church, school, neighborhood, or organization where they can gain access to through children through either volunteering or employment. My predator was my maternal uncle. He was a very well-respected paraprofessional in the medical field in Tucson. When at 12, I told my mother, she yelled at me, "Don't ever tell a lie like that again." As a very young adult, I told my uncle's former wife, my aunt. She told me I must have been imagining things. 25 years later, she admitted to me that she knew I was telling the truth, but hoped that I'd believe her and would move on so it wouldn't continue to harm me. My predator was effective and ensured my silence until in my 30s when both my mother and my predator, my uncle, were deceased. I then told and sought professional help. My story is unique to me, but the research demonstrates the patterns in which predators operate is not unique. Most victims never report their sexual abuse. Most predators remain free to seek to ensure silence as they devour the lives of boys and girls. So this bill allows victims, if they ever have the capacity or feel safe enough to do so, expose their predators and get to tell their stories and might have a sense of justice. Some have argued that this bill would harm insurance companies and nonprofits. While there's no data to support that claim, even if it did, it could not compare to the devastation experienced by the victims. Aren't we better than onlookers who cringe when they see a coyote subdue and devour a rabbit? We stomach it because that's just the cycle of life for animals. Children aren't animals. And if you don't support this bill and let it move on and be passed, I'm left with questions like, why, when you have the power to be advocates for victims, have you chosen not to do so? I didn't know until today that this similar sort of bill has been presented up to 8 years ago. Why would you, who like me, may have yourself been a victim of childhood sexual abuse, or most certainly know or love somebody that has, why would you leave here today and leave the power in the hands of predators? Why would you stand by and cheer for the predator and the power you've handed them while standing and watching the lives around you devastated go through their sexual abuse and just walk away saying, well, that's just the way it goes? I think we're better than that here. And I think we need to quit making excuses and move forward, protect victims, expose predators. Thank you.
Thank you, ma'am.
Gregory Kelly.
You may go around him. He's the furniture here.
Good morning.
Good morning, Mr. Kelly.
My name is Gregory Kelly. I currently live in Gilbert, have been an Arizona resident for 13 years, and am a former candidate for Justice of the Peace in my town. I'm also a survivor of childhood sex abuse who used the civil window in Delaware in 2009 to expose a serial pedophile who had gone undetected for decades. Back in November of 1975, at ages 11 and 12, my brother and I were sexually abused over a 3-night period by the former Judge William C. Bradley, a lifelong friend of my parents, at his home in Delaware. The shock and shame of this experience was so devastating that despite receiving the best psychological care at the time, neither one of us would disclose what happened until we were adults. I would later describe this abuse as the closest thing to death I had ever experienced. Sometime in my mid-30s, I attempted to file an ethics and criminal complaint against Judge Bradley, but it was dismissed because the statute of limitations had expired and because he had not been sworn in as a judge at the time of the abuse. He was about 1 month shy of being sworn into office. In 2009, in what I still consider to be a miracle, I ran across a law called the Delaware Child Victims Act, which allowed for survivors of childhood sex abuse to pursue a civil course of action against their perpetrators. Unfortunately, given the judge's powerful influence in the state, no attorney would take my case, as I had no proof other than my own testimony and that of my brother. As such, I had to file the complaint on my own without an attorney, and Judge Bradley denied all the allegations under the penalty of perjury in his answer. Over the next few months, as my case became public, I was finally able to secure legal representation, and dozens of other survivors of Judge Bradley came forward, willing to testify, even though they were not able to file claims of their own, since the civil window had since closed. It was 2 years at the time, and I found out about it about a year and a half into it. So after those 2 years was up, they were out of luck, but they still wanted to come forward. Faced with the overwhelming testimony of many survivors with no financial interests at stake, Judge Bradley ultimately retired from the bench and admitted to the abuse against me as a child. I later filed for his disbarment as an attorney, which was approved without any opposition from him. It is my belief that without the civil window in Delaware, that Judge Bradley would have continued to molest children until caught, which might never have happened. Sadly, having never come to grips with his abuse in the way that I did, my brother took his own life at age 55 last November. I hope you all give your support to this bill to help put a stop to pedophiles like Judge Bradley, who have managed to escape detection for decades, and to prevent them from continuing to damage the souls of children and their families. I'd like to say one more thing, which is, thank you, which is not written. I have my 5-year-old son here with me today. Unfortunately, this is the world we now live in. Some people think it's completely inappropriate that I'd be talking to my son at such a young age about this subject. I wish my parents had had that discussion with me at age 5. I was 11 years old. I didn't know that a man could do such a thing to a boy. So I proudly talked to my son about this issue because pedophiles are all around us, and in weighing the risk of potential frivolous lawsuits, which there's no track record of in the history of these civil windows being passed, versus the murder of the souls of children, I hope your decision is clear. Thank you.
Madam Chair.
Thank you, sir.
Madam
Thank you for your bravery coming in today and your testimony. I appreciate it.
Madam Chairman.
Any questions?
Madam Chair, I was, this is a, give me a minute.
It's okay. You got time.
As Senator Contreras said, we lost somebody to suicide. The city, one of the cities I represent, was ravaged. I had 12 friends that were abused. Some of them are in prison. Some of them are on the streets. One just recently got out of prison about 2 years ago. And he didn't report it for years because he was afraid. So were my friends. And there were other friends in the neighboring city that also got abused. One committed suicide as well. Senator Contreras and I have been talking about this since this bill came up. And yesterday, I couldn't sleep either. So I was running through my social media, and there was something that came through. It said, when a crime is not punished quickly, people feel it's safe to do wrong. Wrong is a wrong. Madam Chair, you said you'd give this a hearing. So, Madam Chairwoman, with all due respect, I move that SB1101 be given a due pass recommendation, and I move that the Strike Everything Amendment be adopted.
Do you need me to second it? Do you need me to second it? I second that. Oh, he's hiding. Where's your
Members before you, this can be removed from my control. I mean, I could be overruled by the committee. So you have that
Madam Chair, I
option.
would like to overrule the chair if your motion is.
That's what you need to do.
I would like to overrule the chair.
Make that a motion.
I would like to make that motion, madam.
That's the motion you need to make.
Can we just wait?
I make the motion to appeal the ruling of the chair.
I request a roll call vote.
Are you seconding?
I second it.
Yeah, thank you.
I know.
Go. Would you, Mr. Toma, please?
Is there any other motions that you made?
No.
We did not move it. He didn't, it's not. been-
And then she made a ruling
then I
over
made a
here,
ruling.
and now we're appealing.
See, we're
He
appealing.
moved it.
I moved it.
then we
And then I
didn't
appealed the
vote on
ruling of the chair.
I don't remember moving the bill.
We did it.
I moved the bill.
Oh, okay.
Moved the bill. I'm assuming the chairwoman then denied.
Denied the motion.
You're now
So now appealing the ruling of the chair.
Right, Tim, are we good? Yeah.
Yeah.
We're good.
Is that okay? Did we do that right?
you did it.
I think I did. We're all good.
I believe that's what happened.
I denied the motion of the,
She denied.
And and now we're appealing that.
And then he made a motion to overrule me.
Perfect, we're good. I think we're good.
Yeah, I think everybody did everything right. They just didn't get it all. Now, am I under, once this motion has made to overrule, we've voted, and this bill has to go away at this point, right? We cannot do any more testimony
Randy,
after this?
behind you.
Okay.
So can we just have it explained to us one more time what we're voting on?
Right now, we are voting on overruling, so a aye vote is to overrule the chair's decision. A no vote is to go with the chair's decision.
And a result of a yes
Vote.
decision means we then vote
Vote
on the bill
as
and
is.
to strike everything.
And the strike everything.
The strike everything amendment, yes.
We will, do we need to move that again if the motion goes away?
No.
Okay, thank you. Okay. So an aye vote is to overrule my decision. Okay? Is everybody clear on that? Mr. Roberts?
Can I have clarification? Can I have clarification on, it's my understanding as far as a striker amendment that you can only do an amendment in committee, a striker amendment. So will this bill be, is there the possibility of this bill being amended on the floor if this motion were, if your authority was usurped and this bill went through, is there the capability of this bill in current form being able to be amended on the floor?
If the amendment is a non-substantial amendment, but a strike everything can't be done as a floor amendment. So this is a pretty significant change in what the original bill was, because it was 25, and so it would have to be ruled by the lawyers whether or not a strike everything amendment would be needed, and if it is a significant change, then it can't be done on the floor. But an amendment that is not a real significant amendment, and that has to be ruled on by the chairs, whether it's...
To that point, so if there were discussions and stakeholder meetings concerning the one-year window, that could not be touched any longer? Because that would be a substantial amendment on the floor?
Yes.
A committee amendment can be amended on the floor. A strike everything is a committee amendment. A committee amendment can be amended on the floor.
That's correct.
Tim, please confirm.
Madam Chair, yes, that's accurate. A committee
A
amendment.
committee
Roberts.
amendment can be amended
You
on the
cannot-
floor if it's not a significant change
Madam
into
Chair,
what
you
it
cannot
is.
do a new strike everything amendment in committee
Right.
of the whole, but you can amend.
Mr. Boyer, some of the things we're talking about are not
Well,
a strike
that's
everything.
Dr. Freese, he's not a lawyer. We have to have our House lawyers to know if that's a significant change or not. And that's what they've done in the past.
Mr. Roberts, very
I'm
direct.
still unclear as to whether or not, and so what you're telling me is there's varying degrees to how much can be changed in the current proposed strike everything bill if it was to get to the floor. How much could be changed, and whether or not we would have the capability of changing it.
Can you clarify that for us, Tim?
Madam Chair, so if the bill moved forward out of committee with the strike everything amendment adopted in committee, there could be I believe there could be an amendment to that amendment on the floor, but you can't do a new strike everything amendment, but you could do an amendment to the striker on the floor. Yes, that's
Now,
my
Tim, if there's a significant change to the bill and it requires a strike everything amendment, can it be done on the floor? Because
Madam
that's
Chair,
my
no,
understanding.
if it required a new strike everything amendment, you
Yeah,
could not
it
do
could
that.
not.
Madam Chair, I have seen bills, changes on the floor that retain 11 words, and that's it. And we have proceeded
Right.
with that on the floor. It is up to the body, Mr. Roberts. It is up to the body what can be done. 31 people, we can do anything.
Including overrule the chair.
Okay, so everybody's clear on what they're voting on. If you vote aye, you vote to overrule my ruling. Secretary, take the roll, please.
Representative Chavez?
Aye.
Representative Espinoza?
Absolutely.
Representative Fernandez?
Aye.
Representative Fillmore?
Madam Chairman, if I may explain my vote?
You may.
Madam Chairman, I am a solid no on this. There was a time probably about 45 minutes to an hour ago that I would have considered something of this nature. But I believe that Senator Farnsworth was very concise and appropriate in his explanation, which has created in my mind a concern on the clarity of this bill. And I do believe in the decorum and the requirements of how we go through. While I have been known to be a rebel on many issues and cause a lot of consternation and pain in the caucus because I take alternative positions, this is something that's weighed heavily on me, but I do believe that the information that has been put forth on this, I think, is gone beyond the realm of what we were discussing and now has become more of a political football. And with that, I will reaffirm that I'm a solid no on this.
Thank you.
Representative Freeze.
Madam Chair.
You may.
Thank you. The burden of proof lies with the plaintiff on a civil case. I believe that we should have exceptions for the statute of limitations in this very challenging area. Other states are doing such. We are asking for the same consideration. Our state, as Senator Boyer has pointed out, is the strictest in this area. We have room to allow this exception. I just want to be careful as this process, this today, doesn't stop our ability to make this bill better. We must give this bill a chance for the entire body to weigh in on this very serious matter. I'm asking my colleagues on this committee to allow this bill to move forward and have the entire body have a chance to weigh in and give this issue the respect. And Mr. Farnsworth talked about respect. We must respect this issue and allow it to move forward. It is more important to respect this issue than it is to respect a chairman, with all due respect, Madam Chairman. So I think very strongly, please consider those things as you're voting. I vote aye.
Representative Kern.
You may.
Thank you. This is typical government, and it appalls me that at one time, if we were really thinking about the children, at one time in the Judiciary Committee in the Senate, this bill was put on that agenda. It would have created a statute of limitations from now at 20 to 25, even 27 years. But because we did not, or the sponsor did not get this 1 year window, which I'm open to discussing that down the road. But because of that one component, now we are back to square one, and we're probably not going to get a bill out of this legislature because we are disagreeing on something that is very small when we could be helping these victims by setting the age at 27. So here we go again. And hopefully it will not be another 8 years before we get something like this passed, because I know of someone very close to me that was a victim of this. And we have the opportunity to help some of these victims here. But because of pride, arrogance, whatever you want to call it, we are now voting on something that we shouldn't be voting on, and that is overruling our chair, who, by her graciousness and by her willingness to work on this subject, on this issue, at least give you, Senator Boyer, and the victims here a chance to speak so we could hear and work on this issue down the road. But now there's a motion to overrule the chair, which I find appalling, and I absolutely stand behind my chairwoman, and I will be voting no on that. And with that, I vote no.
Representative Roberts.
Madam Chair, may I explain my
You
vote?
may.
There's been a lot of testimony so far on this subject today, and just to reiterate, I think everyone here would like to see work done on this issue. I brought up the issue earlier that in following Representative Kern's some of Representative Kern's comments, I think that in the short time that I've been here as a freshman, I see a lot of bills that have come through that started several years ago, and it continues to be tweaked. So the concept of, just saying that you guys passed something, we don't want to talk about it anymore, I don't necessarily believe that, because I see it repetitively in every single of the 4 committees that I sit on. Many bills come through that originally went through, and we go back and we tweak them, we work on them, we add stuff, we make them stronger, we fix and correct mistakes. I don't think that I don't have confidence right now in this particular situation, and I feel strongly about this issue that it does need to be worked on. But I don't feel confident in the fact that what does need to be worked on can be worked on in the process, as far as whether or not we could. I think we're going to be limited if this bill was to get through on what we actually could do after this committee. And for that particular reason right there, because I think that we're going to be strapped in some way, shape, or form, I'm going to have to be a no on at this time. So with that, I'm a no.
Representative Toma?
Madam Chair,
You may.
thank you. Obviously, this is a very serious issue. I think it seems clear to me that the 30-year suggestion is not controversial, and that the committee can definitely get behind that. The problem seems to be about this 1-year window, and I believe that the chairwoman has graciously offered to work on this with you, Senator, to make sure that we come up with some sort of solution that we can all get behind. This isn't a criminal issue, as we've been told, and I do think that something does need to happen. And to channel a little bit of what Mr. Roberts had stated, I've been told, I've only been here a year longer than you, a year longer than you, sir, and I've already learned that incrementalism sometimes isn't such a bad word, and sometimes we have to start one step at a time, get what we can get done, as frustrating as that might be when you're the proponent of a bill. That said, I will also commit to helping in any way that I can, and pushing a solution that works. I would have hoped to see at least that 30-year be enshrined, right, and pass. But given the positions everyone has taken at this point, I think we need to give the process time to work and make sure that we hold everybody's feet to the fire on this. For now, I'm going to vote no.
Representative Udall?
Yeah.
You may.
Thank you, Madam Chair. Obviously, this is an important issue and one that we need to discuss, and I'm glad that the chair's been willing to hear this bill. I have some serious concerns with parts of this, particularly the 1-year window, as stated by Representative Toma. When the bill was scheduled for Judicial Committee and it wasn't in the form that the sponsor wanted, and he asked to withdraw it, that request was granted. Likewise, when the chair has a strike everything in her name and asks that it not be voted on, I think that request needs to be granted. And so with that, I'm going to vote no.
Vice Chairman Kavanaugh?
Mayor?
You may.
Thank you. For a variety of reasons discussed during testimony, this amazingly is the first time that this bill has received a hearing, and frankly, this is one of the most detailed and lengthy hearings and intricate hearings that I've seen in my time with the legislature, and it's necessary. It brings out concerns. Whether all the concerns are founded or not, we don't know. But we don't have the answers now, because there wasn't adequate input and discussion. There weren't adequate questions brought up in the early stages of this bill at a committee hearing that could have been worked on in the transition between chambers. But we do have the information now. I hope everybody realizes that there would probably be no problem with this bill passing out unanimously of both chambers with the 25 or even the 30-year extension. But the issue is the two issues. I think the big one is the window that needs to be looked into a lot more carefully. And I'm concerned about the liability for first responders who just blow it and don't see the signs. There's teachers, there's police officers, psychologists. There are a lot of people who can be swept into a lawsuit, and with the 1-year window, it could be 30, 40 years down the road when they can't even get witnesses to testify in their favor because everybody's gone or passed away. So again, I hope nobody loses sight of the fact that what I thought was the core of the bill, which was the 25 or 30-year-old extension, is something which has massive support. It's these other difficult issues that need to be worked on. So with that, I vote no.
Well, thank you for those of you that has supported my decision. As you can see, I heard that this issue needs to get respect. I think I just gave it respect. I think we gave it 2.5 hours here in committee. I did not limit testimony. I made sure everybody had their say on what they wanted to say about it. And I wanted to make sure that all the issue was brought up. Senator Boyer, and I know your heart is really into this, so is mine. I wouldn't have brought it today if I hadn't. But I feel like there's some work that needs to be done, especially in that window. I think that there's some things that need to be really tackled in there, and I think that we have to make sure that we're addressing all issues within that. And I didn't feel that this did it today, and so I vote no. Members, by a vote of 4 ayes and 7 nays, you have failed to overrule the chair. We're going to recess until noon.